unfortunately, since we're not doing this in person, we can't really make a game show out of it like I originally wanted to. We can't have our teams. So we are going to do this on the honor system. You will be answering the questions and you will be keeping track of your points. And if you do really well, then you just can be super proud of yourself. How's that? So before we get started, just a few housekeeping things as always. If you have not joined us for webinars in the past, just a real quick overview. The majority of your screen should be the PowerPoint. I am at the bottom right-hand corner. Hello. And on the left, you should see some little icons. One of the icons is a little talking bubble. And so if you have questions while we go through all of this stuff, please just type it in there and I will answer as many questions as I can at the end of the presentation. However, we have a lot of stuff to go through today. We have a lot of different questions to go through. So I don't know how much time we're going to have left. I will try to get to everyone's questions. And if I don't get to your question, then I'll have my email address at the last slide. And you can email me with your specific questions that I didn't get to. Today's a little different. You guys have not received a copy of the slideshow, and that's on purpose. It's because I didn't want you to see all the questions ahead of time and have a chance to look them up, because that's cheating, and so we're not going to cheat today. But you will get a copy of the slideshow after the conclusion, along with the answer key in there. So you will have it to refer back to. You'll get it along with your CMCA credit. So this is eligible for 1 CMCA credit, and those will get automatically emailed out to you. It will be emailed within the next 24 to 48 hours. If you're not seeing it in your inbox by Friday afternoon or Monday morning, give us a shout and we'll make sure we get you one. If you are having problems as far as technical issues, please don't put anything in your little talking bubble thing, because I can't do anything on my end. However, you can call 303-991-2076 to reach Summer Sims, who's our education coordinator. Or you can email her at ssims@altitude.law. All right. So without further ado, let's go ahead and get started with this really, really fun presentation. All right, here we go. Oh, of course, first, we got to have our little dose of humor. So I tried to find one that said community manager, and I couldn't find community manager. So just pretend it says community manager, because I think generally it's pretty similar. And you guys can tell me how accurate this really is. All right. Okay. And now we can really get started. And by the way, you guys have no idea how much time it takes to come up with all these memes for all these questions. And there's like, I don't know, there's like 58 questions that we're going to go through today. So if at some point the memes get really boring, just know it's not easy to come up with all this stuff. Okay, on that note, let's move forward. So allocated interests in a condominium community include the following: square footage of the condominium, undivided interest in the common elements, amenity usage rights, number of votes, A and B, B and D, or none of the above. This is just a made up term. So pick an answer, and the answer that you picked or should have picked is F, as in Frank. Okay, why F as in Frank? Well, because it's B, which is undivided interest in common elements. This is a term that's actually defined in Kiowa, and it's the number of votes. There is also there's a third component which I didn't put in here, and that is your proportion of paying the assessments, right? So it's very similar to undivided interest in common elements. number of votes and your proportion of your assessments. But I just didn't put that in there. Next one. Okay, condominium community. The common elements are owned by. So again, is it the association, the board, the owners, the manager, the attorneys, or the government? Give you a quick second on that. And the answer is C. They are owned by the owners. When you have a condominium community, one of the Kiowa definitions of a condominium is that your common elements are owned in common by the homeowners. The association does not legally own the common elements, but the association does have the legal obligation to maintain, repair, and basically run the common elements. So from a practical perspective, it really doesn't matter who owns them, because it's still the association's right and obligation to control them. Okay. Next. Which of the below is not a common interest community? It's a condominium community with no amenities, a single family home community with no common area, a community that does not have mandatory assessments, a community that does not have articles of incorporation, or a community where owners have no interest in their neighbors. Okay, if you picked C, you are correct. It is a community that does not have mandatory assessments. As you know, the Colorado Common Interest Ownership Act, it governs common interest communities. The term HOA, POA is not actually a defined term. So when we refer to our HOAs, most of the time we're talking about a common interest community. And the definition in Kiowa essentially says, although in a much more convoluted way, it says that by virtue of owning land or property in a community, you as a homeowner are obligated to pay for maintenance of property you don't own, or insurance, or something that is not connected to your specific property. So in other words, if you're paying mandatory assessments, you are going to fall within the definition of a common interest community. So by the same, if you are in a community that does not have mandatory assessments, well, then you are not subject to Kiowa. But there's very, very few of those out there. The difference between a planned development and a condominium development is what? Whether an owner owns land or airspace, the maintenance obligations, how assessments are calculated, whether the units have balconies, or the name of the community. Answer is A. In a condominium community, the homeowner owns the airspace enclosed within their perimeter walls, floors, and ceiling. They don't actually own any land. While in a planned development, and that can be a townhome, that can be a single family community, it can be a patio home community, but in a planned development, the homeowner actually owns the land upon which the structure sits, and the owner actually owns the entire structure. So legally, that's a huge, huge difference. Okay, so that's the general difference. A common interest community may be exempt from Kiowa, and remember, Kiowa is the Colorado Common Interest Ownership Act. So it may be exempt from Kiowa if the developer provides for this in the declaration, the board the board obtains approval from owners representing at least 67% of all the votes of the community. The community is a condominium community with 10 or less units, or the community is a limited expense community where assessments are capped at $300 or $400 per unit per year. So for those of you who picked D, you got it right. I know C was probably tempting as well, because something in the back of your head may be saying, I remember something about 10 or less units. And there is actually an exemption for communities that have 10 or less units or 20 or less units, depending on the year they were created. But that is only for a planned community. It is not for a condominium community. In fact, condominium communities are never subject to exemption from Kiowa. So anytime you see a condominium community, regardless of what you see the declaration, you're not going to be exempt from Kiowa. It's always going to be a planned community, which is, you know, your single family townhomes, patio homes. Which of the below statements is true? Common elements get taxed like other property. Common elements are not taxed. If an association does not pay taxes for common elements, a tax lien may be recorded. Associations do not pay taxes on common area tracts. Owners pay taxes on common area tracts, or D and E, both. The answer here is F. Common area does get taxed, but it is not taxed to the association regardless of whether it's a condominium community or planned development. So even if the association owns the common area, it should not be getting a tax bill. If you have a community and you receive a tax bill for some common area, little red flags should be going off in your heads, and you should be reaching out to the association's legal counsel, because something is probably wrong, or it's not going to be a common area. One of those two. But just because associations don't pay taxes on common area doesn't mean that the government, you know, doesn't collect something on it, because come on, seriously, the government not collecting money, not going to happen. So what happens in reality is the value of the common areas in a community are divided between all the owners in the association, and part of their tax bill includes their portion of the common element. So the government is getting its money from the homeowners, it's just not getting it from the association. So this isn't anything that the government is doing out of the goodness of its heart. All right. An association may regulate which of the below signs? Garage sale signs, political signs when it's not election season, offensive signs, social messaging signs, or holiday signage. So the correct answer is A. Hopefully you guys got that. Why garage sale signs? Well, as you know, the law changed significantly a couple of years ago, year and a half ago. And what happened was the signs and flags got protected to the point where associations are not allowed to regulate them based on their content. But there is one exception that allows associations to regulate based on content, and that's commercial signage. And a commercial sign is generally defined as something that impacts some sort of a monetary transaction or something like that. And so obviously a garage sale sign would fall under that, as well as like a for sale, for rent sign, things like that, advertising signs for businesses, things like that. So commercial signage associations can regulate based on their content, but nothing else. So political signs are no longer protected. Offensive signs, nope, nothing you can do about those, as well as social messaging signs and holiday signs. So it's just the garage sale signs in this particular example. There you go, comedic relief. I kind of like it. I wonder how stable that is. Interesting. All right. An energy efficiency measure includes all of the below except what? Swamp coolers, energy efficient outdoor lighting, air conditioners, retractable clotheslines, or shade structures marketed for energy reduction. I'm hoping you guys all are picking C, the air conditioners. I think if you kind of just think about it, You realize that air conditioners are more energy suckers than savers. An air conditioner does nothing to help a home, conserve electricity. So air conditioners are not defined as energy efficiency measures. The rest of those items actually are, and that term is defined by Kiowa. A pre-Kiowa community. So what is a pre-Kiowa community? Remember, it's a community that was created before July 1, 1992. Okay. And by the way, this meme, I swear I was snorting when I read it. It's so dark and funny. But anyway, a pre-Kiowa community can become subject to Kiowa if it does what? If it fully rewrites its governing documents, if it obtains approval from owners representing at least 67% of all votes in the association, if it obtains unanimous board vote, or obtains approval from owners representing at least 67% of the owners who are present at a meeting, as opposed to everyone. So the answer is D. And the reason I have this question is because so often an association will rewrite its governing documents. They'll have us or their other legal counsel just draft all new documents because they're either old or outdated. And a lot of these communities are pre-Kiowa. And somehow there's a perception out there that once you rewrite your documents, you are now subject to all of Kiowa, like instead of just parts of Kiowa as a pre-Kiowa community. And the answer is no, you're not. You don't become a Kiowa community by simply rewriting your documents. What you need is a separate vote of the homeowners saying we want to opt into all of Kiowa. And although the threshold isn't very high, it's 67% of those who are voting, and of course you will need a quorum of owners to vote, it doesn't happen very often. Okay, so just keep that in mind. When you're rewriting the governing documents, it doesn't mean you become a post-Kiowa community if you weren't created before 1992. Next, Kiowa defines unit boundaries of a condominium when the declaration is not clear. Come on, how often are declarations not clear, right? According to Kiowa, which of the below constitute limited common elements? Exterior roofs? Oh, what am I saying? Exterior doors? I can't, like I'm putting things together. Roofs, windows, interior unit fixtures, A and B, or A and C. So this one I think is pretty commonsensical. The answer is F, A and C. So doors are defined by Kiowa as being limited common elements, and so are windows. But the key to take away is they are still common elements, okay? They're not part of the unit, but they are limited common elements. A lot of times, the declarations are not clear, and they'll say, the unit boundaries are the, finished surfaces of the interior walls, floors, and ceilings, and that's all they tell us. And we don't really know what that means or where the finished surfaces start and end. And so this provision is a good provision to assist with interpreting governing documents for condominiums when we have this kind of language in the deck. All right. Okay, true or false? A developer may not draft a declaration that uses a formula for calculating assessments that would require the developer to pay less than other owners. Is that true or is it false? It is true. However, the developers are getting real smart. So they can't have a provision in the deck that says, while the developer owns a lot, the developer shall pay 50% of the assessments, because that's what we used to see in covenants. And now what they are doing is they're saying the developer doesn't pay, assessments until, or pays 50% of the assessments until, and it's something like a certificate of occupancy is issued. And so that actually so far has worked for our developers to pay less, and basically once the certificate of occupancy issues, they immediately sell then that unit or lot. So, but we can't just blatantly have a provision in the declaration that just says developer pays 50% assessments of what everyone else pays. Okay, which of the below is not a permissible method for an association to accomplish its public disclosures? Now, if you recall, public disclosures, it sounds more ominous than it is, but Kiowa has a provision that says every year the association must disclose certain information to the homeowners. And it's basically, you know, the name of the association, the type of association, the identification of the recording information for the declaration, its managing agent, all that, you know, kind of stuff. And it says you have to update it, you know, within 90 days if there's a change. Otherwise, you gotta do the disclosures every year. And so the question is, there's 3 ways that Kiowa says you can do the disclosures. And so the question is, below, which one is not one of those 3 ways? Sending disclosures via snail mail, personal delivery of disclosures, providing disclosures at an annual meeting, keeping a physical binder with all the information at the principal office, or posting it on the website as long as notice of the website address is sent to all owners by mail or email. So the answer is C, which makes some sense if you think about it. Providing disclosures at an annual meeting is not one of the ways that Kiowa says you can provide them. Now, that makes sense because not everyone's going to be at an annual meeting, right? So if you just do it at an annual meeting, some people aren't going to get the information. If you send it by snail mail, everyone's going to get it. If you personally deliver it, people are going to get it. If you keep a physical binder at the principal office, anyone can come and look at it. And if you keep it obviously on the website and you let everyone know by mail or email that it's on the website, then anyone can access it at that point. So hence the logic. Okay. I love these ones. Okay, enough laughter. Let's go on. Which of the below is not a required good governance policy? So remember, Kiowa has 9 policies everyone has to have. So which one of these is not one of them? So investment of reserve funds, policy and adopting policies, conflict of interest policy, insurance deductible policy, enforcement policy, and reserve study policy. The answer is D, insurance deductible policy. That is not a required policy, although it is recommended. It's not required. When it comes to collection efforts, which of the below statements are true? Owners must be notified they are entitled to a 6-month payment plan. An association may not commence a collection action until it has sent 2 30-day demand letters. A lien must be recorded before a collection action may be filed, or associations may not charge interest higher than 8% of delinquent assessments. And I'm guessing you all knew this one, D. With the changes in the law and all the attorneys harping on you guys to get new policies, get your updated policies. Hopefully the 8% interest cap has been made very clear until it changes next year. I mean, who knows? At this point, we don't know what to expect, right? Oh, and why isn't the 2 30-day demand letters applicable? Well, that's because that refers to an enforcement action, not a collection action. And why is the 6-month plan not applicable? Because now it's an 18-month plan, right? All right. Another true and false. Associations are required to provide owners with education on an annual basis addressing general operations of the association and rights and responsibilities of owners at the executive board. So this one's true. Okay. All right. What is the minimum number of owners that must approve a declaration amendment? So is it a majority of those voting as long as we have a quorum? More than 50% of all owners? 51% of all owners? Whatever number is provided in the declaration? 67% of those who are voting, or 67% of all owners? So the answer is B, as in boy. I hope you all got that. It's not really a trick question, but if those of you who said 67% of all owners, that's the maximum. Okay, and the question is, what's the minimum? So it's not 51%. That's not how Kiowa is written. Kiowa says it's a majority. Okay, so is that a technicality? Maybe, but 51% may actually, depending on the number of units, may actually be a higher amount of owners than 50% plus one owner. So again, there is still a difference there. All right. If an association wants to utilize the court petition process to amend the declaration, it needs to obtain approval from at least who? What? 50% of all the owners, 67% of the owners, half of whatever the declaration requires, 2 attorneys, or 1/3 of the community. So this one a lot of folks get wrong. The correct answer is C. A lot of folks say A, but it's not 50% of all the owners. It's 50% of whatever the declaration requires. So if the declaration says, you know, you need to get approval from 67% of the owners, then it's 33.5% of the owners. So you got to cut it in half, which is usually less than 50% of all owners, right? Okay. If an association wants to utilize the court petition process, it cannot. What can't it do? Change the amendment requirement, change the allocated interest, change insurance, change any language impacting the declarant, change the language impacting first mortgagees, or do anything to upset the judge, because judges can be finicky. Lord knows that's the truth. But the actual answer is B, cannot change the allocated interest. And if you recall from the first question that we did, the allocated interest is what? It's how many votes a homeowner has, how their assessments are calculated, and their undivided interest in the common elements. So you can't change any of that. So if you, for example, have a condominium community where assessments are not equal, they're based on square footage, you wouldn't be able to change that if you were trying to go through the court process. You would have to actually get the homeowner approval requirement that your declaration requires, or the 67%. I love this, by the way, this meme. How mad is she? That is a great name for a flower store. All right, before an association can utilize the court oh, sorry, I didn't realize I had so many court petition questions. But before an association can utilize the court petition process, it must have done which of the below? Held at least 2 meetings with the owners to discuss the amendment, created a summary of all the revisions being suggested by the amendment, consulted with an attorney, sent at least 2 written notices of the amendment to the owners, begged and pleaded with the owners. Well, I kind of feel like E you have to do regardless, but the legal correct answer is D. It is D. You have to send at least 2 written notices of the amendment to the owners. The notices need not say a whole lot. They could say as little as, hey, we're working on these amendments. Keep an eye out for it. It doesn't have to say a whole heck of a lot. Why is A wrong? Hold at least 2 meetings with the owners. It's wrong because you only need to hold 1. Now, it may be a great idea to hold more than 1, but for the court petition process, only 1 is required. All right, comedic relief. Literally. All right. True or false? Per Kiowa, Unless prohibited by the declaration, a board has authority to adopt rules, enter into contracts, impose late charges or for delinquent assessments, and evict delinquent owners. So this is false. It would have been true if we didn't put the last part in there about evicting delinquent owners, but there is no right to evict delinquent owners. These are not apartment complexes, right? All right. Notice the sign is like the same place, this Indian Hills. Whatever this is, I want to go there. All right. True or false? Pursuant to Kiowa, a committee chair must meet the same qualifications as required to become a board member. This one is true. Kiowa does require this. So if you've got the chair of the architectural committee and your bylaws say, you know, to be a board member, you have to be a homeowner, you have to be in good status or whatever else, then the chair must meet all those qualifications to be the chair. Not to be on the committee, but to be the chair of the committee. Kiowa requires a financial audit to be performed when? When required by the governing documents, requested by 1/3 of the owners, when the total revenues or expenditures exceed $250,000 and 1/3 of the homeowner's request, A or B, or A or C. So the answer is E. It's either A or C. So if your governing documents require a financial audit like every year, then you're going to have to do it. If they don't, and your community either takes in or spends over $250,000 every year, and you get a request from at least 1/3 of all the owners, then you have to do an audit in that case as well. The Kiowa budget ratification process deems a budget ratified, which is the same thing really as approved, unless a majority of all owners veto the budget, 67% of all owners veto the budget, a majority of a quorum of owners veto the budget, 67% of a quorum of owners veto the budget. A lot of options here, right? The community manager vetoes the budget, you wish, or the homeowners get angry and throw sharp objects at the board members. Feels like that's an occurrence as well sometimes. So the answer is A. A majority of all owners veto the budget. A lot of folks pick B, 67%. I think that 67% is like a residual number you have in your head, because that's like the cap to amend the declaration is no more than 60%, 67% of all the homeowners. But what Kiowa actually says, it's a majority of all owners or any higher requirement set forth in your declaration. So if your declaration says you need 90% of all the owners to veto the budget, then it's 90%. Otherwise, it defaults to a majority. It can't be a lower number. True or false? Regardless of the Kiowa budget ratification process, a declaration may still require owner approval for a budget as opposed to a ratification. So this one's true. If your declaration says you need to get homeowner approval, like if you want to increase beyond 5% over last year, you're going to have to get owner approval. It means you don't, the ratification process will not trump that, okay? Another meme I love. All right. In a post-Kiowa community, the vote to remove a board member cannot exceed owners representing 67% of all the votes, owners representing 67% of those who are voting, as long as a quorum of owners is present, owners representing a majority of all the votes, owners representing a majority of those voting, as long as a quorum is present, and there is no cap. Whatever is required by the documents must be followed. The correct answer is B. Okay, cannot be more than 67% of those who are voting, as long as a quorum of owners are present. Okay. According to Kiowa, oh, see, there's that Indian Hills place again. See that? According to Kiowa, which of the below provisions must be contained in the bylaws? Number of directors, qualification of directors, which board powers may be delegated, which officers are authorized to execute amendments to the declaration. None of these. Kiowa does not contain requirements for content of bylaws. F, A and B only, or G, A, B, C, and D. The correct answer is G. It is all of those things that are stated up there. All that Kiowa requires that that information be in your bylaws. True or false? Kiowa specifically requires associations to maintain common elements and owners to maintain their units, except as may be provided in the declarations. This is true, okay? So just keep in mind, there is a default maintenance provision in Kiowa, which basically says if your documents don't speak to this, associations are responsible for common elements and owners are responsible for their units, however those boundaries fall. Oh, this is another good one. Sorry, it's blurry. I couldn't find a better version of it. All right. True or false? Kiowa specifically authorizes entry into a private unit as reasonably necessary to perform maintenance, repair, and replacement of common elements into a unit. This one is actually true. It doesn't seem like it's true, but it is. Kiowa does say that. So for those of you, who do need to enter units in order to get to common elements, if you don't have that provision in your document, you still have that authority through Kiowa. All right. Kiowa caps the number of owners required to demand a special membership meeting too. In other words, when you guys get a petition from the homeowner saying, we want you to call a special meeting to vote on removal of the directors, how many homeowners need to sign that for it to be valid? So Kiowa has a cap on that. Is it a majority of all owners? 10% of all owners, 20% of all owners. There is no cap. This is a trick question, or 25% of all owners. So the correct answer is C. It is 20% of all owners. So if you have a set of bylaws that say 25% of the homeowners need to sign a petition for a special meeting before the board has to call it, just lower it to 20. That's what the law says. Can't be higher than 20. Which of the below statements is true concerning notice of regular monthly board meetings? Notice must be provided to owners. Notice must be provided to directors. No notice is required. Notice must be provided to the community manager, and notice must be provided to committee members. The correct answer is C. If you've got regular monthly board meetings, same place, same time, you don't have to provide notice to anyone. Doesn't mean you shouldn't, but you don't have to. At a board meeting, owners must be allowed to speak when? Before the board votes on every issue? Never. Owners are too disruptive and dumb. I hear you guys snickering back then. Only during open forum? Anytime the owner wants to speak, or when they are loud enough to get the board's attention. So the answer is A. It's before the board votes on every single issue. In other words, before you vote, I don't care if you're voting on 5 different things, you got to give the 5 opportunities to speak. C is wrong because it's not only during open forum. Certainly they can speak at open forum if you have one, but you still have to allow them to speak before the vote. The board can go into executive session for all of the below reasons except what? To discuss turning over a delinquent account to collections, to discuss a criminal investigation, employment issues, discuss an opinion letter from the attorney, contract for legal services. Boards should never go into executive session as nosy owners are entitled to know everything. I know that's what, most owners think. The answer is E, contract for legal services. That is not, it's a contract like any other vendor contract. It's not attorney-client privilege. And you should not be going into executive session to talk about that. Unless an association has provided at least 2 30-day cure periods, and we talked about this earlier, so hopefully you remember this. 2 30-day cure periods on a violation. It cannot impose fines against the violating owner, send a courtesy notice to the violating owner, ask the attorney to send a demand letter to the violating owner, initiate legal enforcement proceedings against the violating owner. A and D or C and D? So answer is F. The attorney cannot send anything to the homeowner unless the association has followed its enforcement policy and sent at least those 2 30-day letters, as well as, of course, enforcement proceedings. Can't do any of that. But you can impose fines. We're back to Indian Hills, you guys. True or false, proxies must be allowed during membership meetings regardless of what the governing documents state. True. It's true. Cannot prohibit proxies, cannot limit proxies. You must allow them at membership meetings. Period, end of story. One of my favorite memes, I haven't used it in a long time, so I'm hoping, again, it's blurry, but it's amazing. All right. Which of the below statements is true with respect to proxies? Owners must utilize the association provided proxy form for their proxies to be valid. Proxies must be dated. A proxy must designate a proxy holder. Proxies must be personally delivered, or proxies promote laziness and should never be used. Well, I think we know E is wrong because I just said you have to allow them, right? All right, so the answer to this one is B. The proxies must be dated. You cannot require homeowners to utilize the proxy form created by the association. Hopefully they do, but they don't have to. Okay. All right. What is required for a post-Kiowa community to transfer common elements? Unanimous board approval, whatever is required in the deck, approval from at least 67% of the owners, approval from a majority of all owners, post-Kiowa communities are prohibited from conveying common elements, or A and D. So the answer in this one is C. It is 67% of all the owners. If you are post-1992 and you want to transfer common elements, guess what? You're going to need to go through your homeowners to do it. Which of the below statement is true about a unit owned by a post-Kiowa association? The unit cannot vote. The unit is exempt from paying assessments. The unit cannot be sold without owner approval. The unit must be used as an on-site manager suite or a guest suite. None of the above statements are true. The answer is A. Kiowa specifically says any unit owned by the association does not get to vote on behalf of that unit. A post-Kiowa community is required to carry which of the below insurance coverages? Directors and officers liability, commercial general liability, umbrella, cyber liability. A and B. A, B, and C. So the answer on this one is B. B is the only, none of the other types of insurance are required by Kiowa. You would think like directors and officers would be required, but it's not. Umbrella is not required. Cyber liability is not required. So the commercial general liability policy is the only one out of all of those that is required by Kiowa. Again, doesn't mean you shouldn't have the other policies. You absolutely should. A post-Kiowa condominium community must ensure which of the below items: upgraded fixtures inside units, condominium units themselves, all finished surfaces inside the condominium units, appliances, window coverings inside condominium units. The condominium units themselves, B is the correct answer. Kiowa says, in a condominium community, the association must ensure the units, but you can exclude finished surfaces and you can exclude owner upgrades. When it comes to imposing fines, which of the below statements is true? Associations cannot impose fines until they have sent at least 2 violation notices. Fines may not exceed what is reasonably necessary for compliance. A hearing must be held with the owner present before a fine may be imposed. Associations cannot impose fines greater than $500 per violation, even in the most egregious of violations. Or E, none of the above. The answer is D, cap. We are now, based on the new law, based on 1137, we're capped at $500 per violation, and that's it. Doesn't matter how bad the violation is. The hearing, some of you may have picked C, a hearing is required, but the owner is not required to be at the hearing. So that's the trick there. Homeowner is not required to be at the hearing. So the only thing that's fully correct here is D. True or false? At least one covenant violation notice must be posted on the violator's unit. True or false? So that one's false because it's only one of the collection letters that has to be posted, not the violation letters. So again, I was being tricky, seeing how well you guys memorized House Bill 1137. Which of the below is not an accurate statement under Kiowa? Every unit owner must be an additional insured under the association's policy. The insurer must waive its right to go after the owner for damages, even if the owner was negligent. The insurer cannot accept claims filed by owners. Or property insurance must cover improvements for full insurable replacement cost. Which one of these is wrong? So that the correct answer is C. That's the wrong statement. The insurer cannot accept claims filed by owners. In fact, insurers really should be accepting claims filed by owners. Owners are supposed to be additional insureds under the policy, as A says. And as an additional insured, they are entitled to file claims. I know a lot of times, the insurance professionals will say, no, you got to go through the HOA. Technically, they are wrong, but we don't need to let anyone know that. All right. I hope some of you are snorting at this one. All right. What is the cap on interest that may be imposed against accounts as set forth in Kiowa, against delinquent accounts? 21%, 18%, 8%. Kiowa does not impose a cap. Whatever the declaration provides is fine. Or owners should be charged as much as possible so they stop being slackers and start paying their assessments. So after House Bill 1137, we are now C. 8% per annum is the cap. We used to be at A. Kiowa used to say 21%, but thank you, legislators. We are now at 8. Which of the below records are prohibited from being disclosed to homeowners? Attorney communications, contract bids, board members' email addresses, owners' email addresses and phone numbers, executive session records, or all of the above. If you picked F, all of the above, you are wrong. The correct answer is D. Those are the only things that are prohibited from being disclosed. And again, those are prohibited from being disclosed unless you have written approval from the owner. The other items are things that either the other items are things that the association may choose to not disclose. They don't have to be, not disclosed, but it's optional. So attorney communications, bids, executive session records, those do not have to be disclosed. That doesn't mean they can't be. Board members' email addresses, those have to be disclosed. That is one of the things that is required. Which of the below records must be made available to owners upon request? Ballots and proxies, physical mailing addresses of directors, records of amounts that were received from construction defect settlements, all of the above or none of the above? Answer is D. All of these things that are listed must be disclosed if requested. They are considered corporate records subject to inspection by owners. True or false? Unless specifically prohibited in the documents, the Nonprofit Act allows boards to amend their community's bylaws. The answer is true. It is true. There are certain parts of bylaws that cannot be amended by the board on its own, specifically quorum. For post-Kiowa communities, there are more things that cannot be amended just by the board. So even though associations, boards do have this ability, be careful with what you're trying to amend and make sure you're going through the legal cut. A post-Kiowa association board may not unilaterally, look at this. This is for post-Kiowa, may not unilaterally amend the bylaws to change what? Number of directors, fiscal year, director terms, annual meeting date, or use of proxies. So in addition to quorum, which we just said, none of the boards can change without owner approval. What in here can post-Kiowa boards not change? So the answer is C, director terms. Okay, all these other items actually can be changed. The use of proxies, there's not a whole lot you can regulate with that anyway. A solicitation for vote by a mail ballot must contain what information? So basically when you guys are doing your mail ballots and you're sending them out to the homeowners and you have your letter that goes with it, what information must be contained in that letter? Number of votes needed for the measure to pass, deadline for receiving the votes, quorum requirement, even if quorum is irrelevant to the vote, all of the above or only A and B. So the answer is D, it is all of the above. You do have to provide quorum information, and again, it doesn't matter if it's relevant to the vote or not. You've got to put it in there, and if you don't, it's not going to be a valid vote. True or false? Unless otherwise provided in the bylaws, a written ballot may not be revoked once cast. This is true. So be careful when you're doing your written ballots, because once you get that ballot back from a homeowner, if they come to you and say, I changed my mind, can I give you a new ballot? The answer is no, you cannot. You're stuck with whatever you sent in. You can't change them. Another inspirational meme for all. All right. Don't worry, we're actually going to get done on time. I just don't know if I'm going to have time for all your questions. Which of the below statements is true? When requesting association records, owners must state a proper purpose for the request. Records must be made available within 5 business days of the association's receipt of the request. The association may provide access to records at its next scheduled board meeting as long as the meeting is within 30 days of the request, or associations can deny access to records to delinquent owners. So the correct answer is C. That is the only true statement. Can't request the purpose anymore. The law was changed, so you can't do it. 5 business days is wrong because the answer is 10 days and it's calendar days. So that one, and the act denying access to delinquent owners is also not true. According to the Nonprofit Act, so I just realized nonprofit should be capitalized. That's my typo right there. I apologize. According to the Nonprofit Act, an officer on the board must meet which of the below qualifications? They must be an owner. They must be 18. Must be a resident. Must be in good standing, and or must be liked by the rest of the board. If only, right? So the only correct answer there is B. You have to be 18. Okay. Now, that doesn't mean your bylaws can't require more, but all that the Nonprofit Act requires is that you be 18. True or false? The Nonprofit Act requires director terms to be staggered. Answer is false. It does not. It says they may be staggered. Now, the Condominium Act does require it for condominium communities, but it's only going to apply to condominium communities that are pre-Kiowa. Otherwise, Kiowa overrides it. Oh, sorry. All right, here we go. True or false? A director being appointed to fill a vacancy on the board does so until the next annual meeting. Is that true or false? That is false. They do so for the remainder of the term that the director had, whoever they're stepping in for. So if they had 2 more years on their term, they're getting in for 2 years. In order to resign from the board, a director must submit the resignation in writing, be allowed to step down by the rest of the board, say please, clearly state the intention to resign at a meeting so this decision may be documented in the minutes. Board members are not allowed to resign ever. The answer is A. That's the only thing that's really required is you got to submit it in writing. Other board members don't have a choice whether to accept it or not. Which of the below is a standard of conduct imposed on directors by the Nonprofit Act? There's actually 3, but which of the below fall under that? The duty to attend meetings, the duty to act with the care of an ordinarily prudent person, the duty to be good looking, the duty to never be wrong. A and B, or A, B, and D. So the correct answer is B, to act with the care of an ordinarily prudent person. If the bylaws and articles are silent as to the number of directors, the Nonprofit Act requires what? 3 directors, at least 1 director, 5 directors, 1 director for every 25 units, 1 director for every 50 units. And the answer is B, at least 1 director. Ha. All right. All right, let me see if I can get 2 questions. All right. Okay, so some of these are just comments. Can you watch this again? Can I watch this again on YouTube? Yes, this will be on YouTube. It'll be on our YouTube channel. Probably today or tomorrow we'll get it on there. Will there be an answer sheet? Yes. For those of you who missed the very, very beginning, there will be an answer sheet. It's going to get emailed to you with all the slides and the correct answers. It's going to be emailed along with your CMCA credit. All right, and I see that that's already been answered. Why can't the board change quorum for an annual meeting if the bylaws allow the board to amend it? The simple answer is because the statute says you can't. So you can't have a provision in your documents that violates what the law allows you to do. So that's, you know, the real answer to that one. It's kind of like when the mom says, because I told you so. Honestly, I don't see any other questions. Okay, guys. Well, we are right on time. Thank you so much. I hope you got something out of it, and we'll see you next time. Bye-bye.